Have you ever looked around your home, the place where your children grew up, the place where you celebrated birthdays, holidays, and family milestones, and thought to yourself, this house is secure, this house is ours, no matter what happens, this home will always be here for us? If so, I want you to pay very close attention to what I am about to share today, because thousands of families across the United States are discovering a shocking reality in 2026. They are learning that the very document they thought protected their home may actually be setting them up for one of the most frustrating legal and financial nightmares imaginable. The frightening part is that most people never see it coming. Everything appears perfectly normal until one unexpected event suddenly turns their home into an asset they cannot sell, cannot refinance, cannot transfer, and in some cases cannot even fully control. The problem often comes down to something that sounds incredibly simple: a name on a deed. Now, before we go any further, let me explain why this matters so much. For most families, especially immigrant families who came to America seeking opportunity and stability, a home is not just another asset. It represents years of sacrifice. It represents long shifts at work, missed vacations, careful budgeting, and countless personal sacrifices. For many immigrants, buying a home is the ultimate symbol of achieving the American dream. It is proof that all the struggle was worth it. But what happens when the legal structure behind that home creates a trap that nobody warned you about? What happens when one spouse leaves the country, becomes unreachable, passes away unexpectedly, or becomes involved in a legal dispute? Suddenly, the house you thought you owned becomes a legal puzzle that can take months or even years to solve. Let me tell you about a situation that attorneys across the country have been discussing more frequently in recent years. Imagine a married couple purchases a home together. Both names are placed on the deed because that seems completely reasonable. After all, they are husband and wife. Everything goes smoothly for years. The mortgage is paid on time, the family settles into their community. Then life changes. One spouse faces immigration difficulties and is ultimately forced to leave the United States. Suddenly, the spouse remaining in America discovers something they never expected. They cannot simply sell the home. They cannot just sign paperwork and move on. Because both names are on the deed, both owners must generally participate in the sale. Buyers become nervous, title companies hesitate, lenders refuse to proceed. What looked like a straightforward real estate transaction suddenly becomes a legal obstacle course. Many people assume deportation somehow removes a person's ownership rights to property located in the United States. That is not how property law works. Property rights and immigration status are separate legal issues. Even if someone is removed from the country, their ownership interest in the property typically remains intact. Their name remains on the deed. Their legal rights continue to exist. While that may sound fair, it creates a practical problem. If that individual is living thousands of miles away, perhaps in a country with limited access to legal services, obtaining signatures and completing legal requirements can become incredibly difficult. Families find themselves trapped in a situation where everyone agrees the home should be sold, yet the sale cannot move forward because of paperwork complications. What makes this even more stressful is the fact that many families only learn about these requirements after they have already found a buyer. They may have packed their belongings. They may have made plans to relocate. They may even have another home under contract. Then suddenly they hear words that completely change everything. The title company explains that additional legal documentation is required. Attorneys become involved. International notarization procedures must be followed. Government certifications may be necessary. Weeks turn into months. Sometimes months turn into a year or longer. During that time, mortgage payments continue. Property taxes continue. Insurance premiums continue. Financial pressure builds with every passing day. Now let us consider another situation that is equally devastating. A spouse passes away unexpectedly. Most people assume that if they are married, ownership of the home automatically transfers to the surviving spouse. Sometimes that is true. Sometimes it is not. The answer depends on how the property was titled when it was purchased. This is one of the most misunderstood areas of real estate law in America. Millions of homeowners have no idea how their property is legally titled. They signed paperwork years ago during closing and never thought about it again. Yet those forgotten documents can determine whether a surviving spouse gains immediate control of the home or becomes trapped in a lengthy probate process. When probate enters the picture, families often discover how complicated the legal system can become. Court filings are required, deadlines must be met, legal notices must be issued, creditors may have rights, potential heirs may have rights, disputes can arise unexpectedly. A process that appears simple on the surface can quickly become overwhelming. During this period, selling the property may require court approval. Transactions slow down dramatically. Families already grieving the loss of a loved one find themselves facing legal challenges they never anticipated. The situation becomes even more complicated when there is no will. Without a valid estate plan, state laws determine who inherits property. Many people are shocked to learn that inheritance may not always follow the outcome they expected. Family members who were never considered part of the conversation may suddenly acquire legal interests in the property. Adult children, parents, siblings, or relatives from previous relationships can become involved. Every additional person creates another layer of complexity. Every additional legal interest creates another potential obstacle to selling or transferring the property. Then there is divorce, a situation that unfortunately affects countless families every year. When a marriage breaks down, disputes over property often become some of the most emotional and contentious issues involved. In many cases, legal notices are filed against the property. Potential buyers become unwilling to proceed. Title insurers refuse coverage. Mortgage lenders withdraw their approval. The home effectively enters a state of legal limbo. While the court process slowly moves forward, the property remains frozen. Months pass, sometimes years pass. Meanwhile, financial obligations continue accumulating. Mortgage payments still come due. Property maintenance remains necessary. Insurance must remain active. The economic burden can become enormous. For immigrant families, there are additional layers of complexity that many people never anticipate. Property ownership can intersect with tax law, immigration law, estate planning law, and international legal procedures. A decision that appears simple on the surface may trigger unexpected reporting requirements or create future complications. Families often discover these issues only when they attempt to sell a property, transfer ownership, or settle an estate. By then, correcting the problem can be far more expensive and time-consuming than addressing it proactively. One of the biggest mistakes people make is assuming that because everything appears fine today, everything will remain fine tomorrow. Life does not always provide warnings. Illnesses occur unexpectedly. Accidents happen. Relationships change. Immigration cases take unexpected turns. Economic circumstances shift. The legal structure surrounding your home needs to be prepared for those possibilities before they occur, not after. Waiting until a crisis arrives often limits your options dramatically. This is why legal professionals consistently emphasize the importance of reviewing property ownership documents. Understanding exactly how your home is titled may be one of the most important financial tasks you ever complete. A simple review today could prevent years of legal headaches tomorrow. Yet many homeowners have never even seen a copy of their recorded deed since the day they purchased their property. They have no idea whether the ownership structure aligns with their current goals and family circumstances. Estate planning is another area that families frequently postpone. They tell themselves they will handle it later. They assume there will be plenty of time. Unfortunately, later does not always arrive. A properly drafted will, a thoughtfully designed trust, and carefully prepared powers of attorney can dramatically reduce the likelihood of future complications. These documents do not eliminate every problem, but they can provide clarity and direction when families need it most. Perhaps the most important lesson from all of this is that prevention is almost always easier than correction. Once a legal dispute begins, once probate starts, once ownership questions arise, solving the problem often requires attorneys, court proceedings, government filings, and significant expenses. Taking action beforehand is usually faster, less stressful, and far less costly. So if you own a home today, especially if you are part of an immigrant family, do not assume everything is fine simply because nothing has gone wrong yet. Pull out your property records, review your deed, understand how ownership is structured, discuss your situation with qualified legal and tax professionals. Make sure your estate planning documents are current. Confirm that your family knows where important records are located. These simple steps could protect your loved ones from enormous hardship in the future. At the end of the day, your home represents much more than bricks and walls. It represents security, stability, and the future you are building for your family. Protecting that future requires more than making mortgage payments. It requires understanding the legal framework that governs ownership itself. Because when unexpected events occur, and life has a way of bringing unexpected events to all of us, the difference between a smooth transition and a years-long nightmare often comes down to decisions that were made long before the crisis ever arrived. That is why the smartest time to review your property ownership, your estate plan, and your legal protections is not during an emergency. The smartest time is right now, while everything is stable, while you have options, and while you can make thoughtful decisions without pressure. The families who take these steps today are often the families who avoid devastating problems tomorrow. And when it comes to protecting your home, your finances, and your loved ones, that preparation can be worth more than you can possibly imagine.